Good morning, everyone. My name is Michelle and I'll be your webinar moderator today. Today's webinar is sponsored by NatRoad's Platinum partner, Bridgestone. Tires are your vehicle's only point of contact with the road. That area of contact is the size of your hand, meaning the lives of you and your loved ones are riding at great speed on just 4 handprints of tread. That's why it's important you choose a tire brand you can trust. Today's webinar is being presented by NatRoad's own in-house advisors, Melanie, Tate and Richard Calva. Melanie Tate is a lawyer who started with NatRoad as an in-house advisor in November 2021. Melanie has a background in family law, business and project management, and is one of the friendly advisors supporting NatRoad members with their IR, HR, compliance, and COVID-related inquiries. Richard Calver is a lawyer with over 40 years' experience in providing advice to a range of industries and private clients. He has been with NatRoad on a full-time basis since 2017. He has expertise in workplace relations and general commercial law, as well as being immersed in the details of the HVNL and road traffic law. Like always, we'd love to hear from you during today's presentation. If you have a question, please feel free to type it in the Q&A section at the bottom of your screen. You may send in your questions at any time during the presentation, and we'll answer them at the end of the session. So welcome, everyone, and first we'll hand over to Richard.
Thanks, Michelle. Today's webinar will focus on 3 subject areas that members have sought advice about. We continue to base our policies in the areas of research on subjects that are important to members. We're membership driven. So first of all, I must say that COVID has changed a great deal about how we operate, how members operate, and Mel will look at one aspect of that change, mandatory vaccination and the employer's work health and safety duty of care. We've had a large number of inquiries about how to deal with the issue of vaccinations, and Mel's explanation of this subject consolidates that advice. Before I turn to Mel, though, I'll start by talking about the implications of a recent High Court case that dealt with a dispute between 2 truck drivers and a company that initially employed them and made them contractors. This case assists to draw a line between when truck drivers are contractors rather than employees. After Mel's section on COVID, I'll then return to discuss an issue that's recurring. The question is, when does the long distance award, the Road Transport Long Distance Operations Award 2020 apply when compared with the Road Transport and Distribution Award 2020? So, the Jamsek case. It's not often that a case involving owner-drivers gets all the way to the High Court. The case of ZG Operations and Jamsek was the exception. The case was handed down on 9 February this year after a considerable delay. There were parts of the judgment in the full federal court from which the appeal to the High Court was made that were concerning to NatRoad and members. So let's start with the facts. Here we are. Between 1977 and 2017, Mr. Jamsek and Mr. Whitby were engaged as truck drivers by a business run by ZG Operations, which was a lighting company. They started out as employees, but then in 1985, ZG Operations offered Mr. Jamsek and Mr. Whitby the opportunity to become contractors. The drivers agreed to the new arrangement and set up partnerships with their wives. Now, let's just interpolate there. It's unlikely that that behaviour would be lawful today because the Fair Work Act contains provisions about general protections that would prevent adverse action being taken against them. That is, either you become contractors or lose your job. That wouldn't happen. But the general protections law is the subject of another whole webinar, so we won't dwell on that. But that's the critical point here, that they were given the opportunity to become contractors. That would be unlawful in today's environment. Each partnership, though, at the time in 1985, signed written contracts with ZG Operations for the provision of delivery services. The partnerships purchased trucks from ZG Operations. They paid the maintenance and operational cost of those trucks. They invoiced ZG Operations for delivery services and were paid by ZG Operations for the provision of those services. income from the work performed for ZG operations was declared as partnership income for the purposes of income tax. And this was a very important deciding factor in the case, because that income was split between Mr. Jamsick and Mr. Whitby and their wives. So it operated, in all respects, it wasn't a sham, as a real partnership. Could I have the next slide, please? So, Mr. Jamsick and Mr. Whitby commenced proceedings in the Federal Court of Australia, seeking declarations that they were entitled as employees to be paid superannuation, long service leave, and annual leave entitlements. They claimed to be owed those entitlements because they were employees and had been employees the whole time. In the High Court, it was unanimously held that Mr. Jamsick and Mr. Whitby were not employees of ZG operations. So, the majority of the High Court held that where parties have comprehensively committed the terms of their relationship to a written contract, and that written contract's not challenged on the basis, for example, it's a sham, which was not the case in ZG. The labelling of that relationship as one of employment or independent contracting must proceed by looking at rights of obligations of the parties under the contract. So, as I said, after about 1985, the contracting parties were the partnerships and ZG operations. The contracts between the partnerships and ZG operations involved the provision by the partnerships of both the use of the trucks owned by the partnership and the services of the driver to drive those trucks. Maybe the next slide. The partnerships became independent contractors to ZG operations because of ZG operations' refusal to continue to employ the drivers and its insistence that the only relationship between Mr. Jamsick and Mr. Whitby and ZG operations would be a contract for the carriage of goods. This relationship was found not to be an employment relationship, even though some of the subsequent conduct seemed to point to that label. Now, a worrying example used in the full federal court when we breathed a sigh of relief about not being considered as important by the High Court related to goodwill. Now, the fact that the contracts excluded the right of the owner-drivers to accrue goodwill was considered to be a pointer to an employment relationship in the full federal court. As I said, that was alarming to NatRoad, and some members called about it because there are a large number of contracts out there, and there are no contracts that I'm aware of where the hirer agrees that an owner-driver accrues goodwill. So for the full federal court to put emphasis on that was a real worry. So let's just remind ourselves, goodwill means a payment that is over and above the market price of a vehicle that you're buying from another person. That's a payment for the value of the business and is usually paid in the expectation that the truck will be sold as in work under an existing contract. So why is it that goodwill is not recognised in this way? Well, goodwill payments create a higher entry price into the industry, meaning margins are even tighter than the current 2.5% profit margin. And it's harder to make a profit for those people paying that higher price. They've also been a cause of unfairness and disputes. For example, new drivers paying goodwill for a vehicle that is under an existing contract in the expectation they will get the work, but they're not being taken on by the hirer and losing the money they paid as goodwill. And also drivers paying a goodwill payment to get into the work, but they're not being able to recover that payment when they decide to leave the business later on. So the full federal court emphasis on the exclusion pointing to an employment relationship, the exclusion of goodwill, not applicable in the face of the High Court's decision, means we breathe a sigh of relief. So next slide, please. So it's now over to Mel. The message that I want to leave you with, though, before I hand fully to her, is that this decision reinforces the need for written contracts. Wherever possible, have a written contract. Thanks. Mel, over to you.
Thanks, Richard. And as Richard explained, I will be talking today about mandatory vaccinations and the employer's obligation to ensure a safe workplace. Australia's uptake of the COVID-19 vaccination has been high. This is due in part to state-based enforceable public health orders, which have required certain classes of workers to be vaccinated if they are to undertake their work outside of their home. Under work health and safety laws, employers have a duty to eliminate, or if that is not reasonably practicable, to minimise the risks of COVID-19 in the workplace as far as reasonably practicable. Additionally, employers have a duty to consult with their workers regarding COVID-19 risks and how these risks are to be managed, and this includes any introduction of a workplace policy relating to vaccination. The gathering of information through employee consultation will assist each employer in assessing whether implementing a COVID-19 vaccination policy is a reasonably practicable control measure to manage the risks of COVID-19 in the employer's workplace. Whilst the vaccines assist in keeping the community safe and helps to protect people by preventing serious health effects of COVID-19, a vaccinated person can still unknowingly be infected with COVID-19 and spread the virus, and this includes to workers and others in a workplace. As such, even if a workplace has workers who are all vaccinated, in order to meet the duties under the work health and safety laws to minimise the risks of COVID-19 in a workplace, employers must continue to implement all other reasonably practicable COVID-19 control measures, such as ensuring workers do not come to work when they're unwell, practicing social distancing, improving ventilation where it's appropriate or possible, practicing hygiene, increasing cleaning and maintenance of the workplace, and of course, wearing face masks. Even if a vaccination is available to all of a workplace's workers, this does not necessarily mean it is reasonably practicable to require mandatory vaccinations in a workplace or to all of the workers. The risk assessment undertaken of the workplace might indicate that a workplace can meet all WHS duties by applying some other control measures, as detailed above, to address the risks of COVID-19. In addition to meeting WHS obligations, employers must also comply with any public health orders made by state and territory governments that apply to them and their workplace, and this includes those mandating vaccination of certain workers. The federal government has not mandated vaccination. However, it has endorsed the state-based mandates for workers in aged care settings. And generally speaking, the states have issued directions which require employers to notify all employees of the vaccination requirements, ensure employees do not enter or remain at a work premise if not appropriately vaccinated, unless of course they hold a valid medical exemption, and they maintain a written record of all employees' vaccination status or exemption where applicable. All employees must provide evidence to their employer of their vaccination status. In New South Wales, orders provide that some workers in certain sectors are required to have been vaccinated with a double dose of COVID-19 vaccine. These include healthcare, aged care, and education. The requirement to be vaccinated will be dependent on the nature of the worker's role and whether they come into physical contact with members of the community. In other industries, employers may only collect evidence of vaccination status of their workers in limited circumstances. Victorian orders required workers in certain industries to be vaccinated and required these employers to collect and maintain records about the vaccination status of their employees and the date the employees became fully vaccinated. This includes all freight and logistics workers. In addition, all interstate workers are required to be vaccinated and carry their proof of vaccination status. Employees or workers who fall within the mandatory vaccination orders must disclose their COVID-19 vaccination status to their employer. Employees who refuse or have failed to do so are to be considered as unvaccinated. Workers who are eligible for their third dose on or before the 12th of January 2022 must have received their third dose or booster shot by the 12th of March this year. In January, the Victorian government further imposed obligations on employers not to permit workers to work outside of their homes if they were not fully vaccinated or hold an exemption from vaccination for medical reasons. Queensland orders mandate that all workers, again in healthcare and high-risk settings, which includes aged care facilities and disability providers, be vaccinated, and also provides that any worker who works at any of these facilities is not permitted to enter or work or provide services if they've not been vaccinated with 2 doses of vaccine. Employers are permitted to make a lawful direction requiring an employee to be vaccinated, and this is in circumstances where the employer determines that it is a requirement of the employee's role. In South Australia, several high-risk industries are subject to mandatory vaccination. For industries not covered by mandatory vaccination directions, the vaccine should be considered as a control measure to minimise COVID-19 exposure risks in the workplace. And where a risk is identified, an employer must eliminate or alternatively reduce the risk so far as reasonably practicable. Mandatory vaccination directions also apply in Tasmania for workers in settings, once again, which are considered high risk. Again, these are aged care, medical, disability, childcare and healthcare. From the 1st of April this year, workers in these high risk settings will be required to have their booster dose. And for all other workers, vaccination is considered a control measure. The ACT has issued directions for workers in, again, high risk and crucial employment sectors. This is including residential aged care, education, and again, health services. Workers in these industries were required to have received 2 doses or be fully vaccinated by the 13th of December last year. And as of today, there has been no directions made for these workers to receive their booster dose. In the Northern Territory, as is similar with other jurisdictions, workers in certain settings are to be fully vaccinated and are required to show evidence of their vaccination status to their employer. This includes workers who come into contact with vulnerable people, a particular workplace poses a high risk of infection, or the work performed is necessary to the operation or maintenance of essential infrastructure in the Northern Territory. Workers in healthcare, hospitals, aged care and disability must have received their 3rd dose or booster shot by 11 March 2022. All other workers under the mandatory vaccination directions must have received their booster shot by the 22nd of April this year. This includes logistic workers in the Northern Territory. In Western Australia, vaccination is mandated for a majority of high-risk industries, including those with people at an increased risk of being infected with COVID, or people who are vulnerable to the impacts of COVID, or in circumstances where it is necessary to avoid the risk to the community of this, or the risk of the safety of the community. My apologies. Unlike most other state jurisdictions, the WA orders are industry specific and have different commencement dates and exemption criteria. The WA policy is being implemented in a phased approach, and this has been expanded to include a requirement that all critical workers are vaccinated in order to attend work in the event of a lockdown or other similar restrictions. Cross-border freight workers, including rail and road, were required to be fully vaccinated by 24th of December last year, with the remaining freight and logistic workers to have been fully vaccinated by the 31st of January this year. Each employer or person in charge of a workplace must ensure that their employees are vaccinated against COVID-19 or have provided sufficient evidence for an exemption from vaccination. For industries not covered by the mandatory vaccination directions, vaccination is considered as a control measure to minimise COVID-19 exposure risks in the workplace. Other recommended control measures include physical isolation, workplace bubbles, minimising contact, physical distancing, wearing face masks, encouraging good hygiene, and of course ensuring unwell employees do not attend the workplace. In summary, under the Fair Work Act, employees must comply with any lawful and reasonable direction of their employer. Whether an employer's direction for an employee to be vaccinated is reasonable will depend on the circumstances of their employment. Although the health directions in the states and territories are broad, they do not apply to all industries. And employers are still subject to health and safety legislation to ensure that they provide a safe workplace. Employers who are not covered by the health directions and who wish to implement a direction for employees to be vaccinated must engage in a consultation process with their employees before implementing a vaccine mandate. They must consider whether there are other safe and effective alternatives. And they must also take into consideration any specific objections of employees, being mindful of specific medical reasons for not being able to be vaccinated, and of course, their obligations to avoid discriminating against employees either directly or indirectly. Provided the consultation has been properly undertaken, it is likely that an employer direction for employees to be vaccinated will be considered reasonable in circumstances where employees are to closely interact with other employees and or the public. And a couple of recent cases have been decided in which a number of courts and tribunals have upheld the vaccine mandates. By way of example, in this case, the Supreme Court of New South Wales found the New South Wales public health orders mandating COVID-19 vaccination for some workers were not unlawful. And case number 2, Allcamp and Associate for Christian Senior Citizens Homes. In this case, the Fair Work Commission held that there was a valid reason for the dismissal of an employee that refused to be vaccinated in accordance with a government-issued vaccination mandate. Further, the Fair Work Commission held that if the employee continued employment with the association, this would have constituted an offence against the mandate, with the association potentially being subjected to financial penalties. And on that note, I'll leave you with a couple of funnies just to lighten the mood, and I'll hand back over to Richard.
Thanks, Mel. So if we can go to the next slide after everybody's had a good look at those mask leftovers. Thanks. So the third and final issue, we're in the home straight here, people. Let's look at the 2 transport awards that govern employment in the road transport industry. As I said before, they're the Road Transport Long Distance Operations Award 2020 and the Road Transport and Distribution Award 2020. Next slide, please. So the member question we get is, we've got some drivers covered by the Long Distance Award who also work from time to time under the Distribution Award doing local work. How do I apply both awards? Well, these awards are unique to the modern award system, and they are hand in hand. Originally, when the modern award process was commenced, there was only going to be one award, but in their wisdom, the then Australian Industrial Relations Commission, now called the Fair Work Commission, decided there'd be 2 awards. So let's start with the local awards coverage, because it says that the award covers the employers throughout Australia and the road transport and distribution industry and their employees in all of the classifications that are listed in Schedule A. They do that, it does that to the exclusion of other awards. Coverage is excluded under clause 4.3 of the distribution award, where employees are covered by the long distance award whilst undertaking long distance operations. So you're covered principally by the Road Transport and Distribution Award unless you're doing long distance operations. Therefore, the Distribution Award applies unless a long distance operation is undertaken, and the classifications in the Distribution Award are based on the same descriptions and grades for drivers in the long distance award, except the grades 1 and 2 only exist in the distribution award. So the long distance award starts from grade 3 under the distribution award. It's the interaction between these two awards that's an issue, given their unique interdependency. And that it causes problems for some members, because what does whilst undertaking long distance operations mean? Remember, you're under the distribution award unless you're undertaking long distance operations. Well, that phrase is best to be looked at via two definitions in clauses 2 of both awards. And the critical point is that long distance operation means any interstate operation or any return journey where the distance traveled exceeds 500 kilometers. And the operation involves a vehicle moving livestock or materials, whether in a raw or manufactured state. Obviously, I'm quoting now, from a principal point of commencement to a principal point of destination. So what have you got to establish? It's a journey of 500 kilometers unless it's an interstate operation, and it's from a principal point of commencement to a principal point of destination. There's an area within a radius of 32 kilometers from the GPO of a capital city, which is deemed to be that capital city. So if you say you're sending someone from Sydney to Melbourne, as long as when they get to Melbourne, the destination's within 32 kilometers from the GPO, then that is a Sydney-Melbourne journey. Now, the interstate operation is moving a vehicle from that same principal point of commencement in one state or territory to a principal point of destination in the other state or territory of 200 kilometers. So either you've got an intrastate journey of 500 kilometers, or you've got an interstate journey of 200 kilometers. So you're covered by the Road Transport and Distribution Award unless you're going from a principal point of commencement to a principal point of destination with interstate or interstate 200 kilometers. So as simply as I can put it, a long distance operation is therefore one which exceeds 500 kilometers from a principal point of commencement to a principal point of destination, or an interstate journey in excess of 200 kilometers. So the two awards are structured so that overlap between the two awards is contemplated, and therefore you've got to look at compensation adjustment. In 2012, there was an absolute recognition by a senior deputy president of the AIRC, as it then was, that there's a recognition in the long distance award for transfer from the distribution award per an allowance. Now that allowance is now contained in clause 18.2C of the long distance award. So if you engage someone under the Road Transport and Distribution Award and you get them to do a long distance operation, then on each occasion that you get them to do that, you've got to pay them an allowance under clause 18.2C1 of $10.98 on each occasion. There's no allowance paid from a transfer for the long distance award to the Road Transport and Distribution Award though. Can I have the next slide, please? So just reinforcing this, the two transport awards are absolutely unique. They're interconnected, and you can switch between two of them. That's recognised in the long distance award under clause 18.2C1, because you have to pay $10.98 on each occasion. So how you define that in your employment terms and conditions is very important, and how you define your principal point of commencement to principal point of destination is also important. So what we say, if you've got employees who regularly transfer, the best way to proceed is to have what's known as an individual flexibility agreement. And the awards themselves set out what an individual flexibility agreement is that references back to the Fair Work Act. And as long as they're better off overall, having regard to the pattern of work that they do, then an individual flexibility agreement means you won't have to work out when there's an occasion where you have to pay the allowance, because that'll be built into a higher, maybe a flat rate. And it should be based on the best estimate of work between those two awards over a recent period that you can gauge, that will give you some guidance about what the future will bring. Otherwise, for example, the problem is that the Australian Tax Office requires you to prorate super payments between the two awards, and payroll can be made difficult. So it's much better to have an individual flexibility agreement. So the message that I had before, both engagement of a contractor and the engagement of employees, is put it in writing. Put it in writing on every instance, because for switching between these two awards under an individual flexibility arrangement, it will be clear to everyone what the pays are and what the superannuation is. It'll make it a lot simpler. And engaging a contractor, the High Court has stressed that that written contract will be given precedence. And I think that's the final slide now, please, Mel. Yes, it is. So back to you, Michelle, for questions.
Great, thank you, Melanie and Richard. Our first question is, you emphasised in the presentation that it is important to have in place a written contract. Is there any law that already requires contracts with transport operators to be in writing?
Well, I'll handle that, Michelle. The answer is yes. If you're a Victorian and you're hiring owner drivers, that is an enterprise or an individual that has 3 or fewer trucks, one of which is driven by the owner, you must have a written contract in place. Section 20 of the Owner Drivers and Forestry Contractors Act requires hirers to use written contracts. And recently, the Victorian Wage Inspectorate has been out there auditing hirers to make sure they've got written contracts. The threshold for when one needs to be put in place is if they're engaged with no fixed time period or duration in the contract, or where the contract's for longer than 30 days. So that's in most instances. And Section 20 of the Owner Drivers and Forestry Contractors Act it's really familiar to me, because we've got on our webinar history a webinar done by the Victorian Wage Inspectorate where they talk about what's got to be in those written contracts. And one is the rates, any guaranteed minimum number of hours, and the amount of notice you've got to give to terminate a contract. So yes, if you're in Victoria and you're engaging an owner driver, then you've got to have a written contract in place. If you're an owner driver yourself, make sure the hirers know that they've got to have a written contract in place, otherwise they can get a fine. Yeah.
Great, thank you, Richard. We have one more question. I have drivers who sometimes drive a B-double to move it from one depot to another, but we employ the driver to mostly drive singles. Does the driving of the B-double affect his pay?
The short answer is yes, it does. Let's assume that the driver is engaged to do local work, and there's a provision in the Road Transport and Distribution Award. That's clause 17.4. And it's what's known as a higher duties provision. Here it is. It says where an employee is required to perform 2 or more grades of work on any one day, the employee is to be paid the minimum rate for the highest grade for the whole day. So if you get that driver to move a B double from one depot to the other at the end of the shift. They've been driving a single for 8 or 9 hours. You're going to have to pay them that 8 or 9 hours at the B double rate. So it's a trap for players. Even if it only took them half an hour to move the B double between depots, you've got to pay them the whole day at that B double rate. So be careful of getting people who are normally engaged to drive at a lower rate, getting them to drive higher rigs that they might be licensed for, because you might get a surprise about the amount you've got to pay them. Thanks, Michelle.
Thank you, Richard. Well, that concludes today's webinar. Thank you, Melanie, and thank you, Richard, and thank you everyone for attending. If you have any other questions, please send an email to info@natroad.com.au. Today's webinar will also be uploaded to the NatRoad website, so please share it with your colleagues. Thanks again for attending and enjoy the rest of your day.